What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are breaking down Alan Jackson's closing argument for the defense. I was going to try to do them both on one video, but I want to give each the time it deserves. These closing arguments were incredibly important, very different styles, and there's just so much of them I want to play and basically react to this like Monday Morning Quarterback. Like if I'm a quarterback reviewing game tape of another quarterback, oh, that was a good point. This was a good point. How did he tie this together? What witnesses did he use? What did he not use? We're going to go through it in its entirety. We're going to talk about jury being deliberating right now. How long it's going to take? What do we think is going to happen? And if a jury question comes out while we are live, we will play it. We will answer it. We will talk about it together. Make sure you guys hit that like button. Let's get to it. All right, Alan Jackson giving the closing argument for the defense. No surprise there. How different will it be than proving a conspiracy and that Karen Read is innocent and sits there as someone who is framed and the jury needs to determine that? Seemed like it was going to be more of a reasonable doubt argument this time based on opening statement, based on the way a lot of the evidence was presented, but they did not fully abandon that Brian Higgins did this, that the cops maybe covered it up, that there is corruption there, and that there is somewhat of a conspiracy, although I believe that word was used more by Hank Brennan than it was by the defense team. Let's take a listen to Alan Jackson.
Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Read, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable.
If you remember when I talked about what I would do in my opening statement, a lot of it focused on the criminal justice system. So I love starting out with that and making sure they all understand what is reasonable doubt and how is it defined and did they prove it?
Operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Read sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty.
Clear as day. Crystal clear. Explain to them, what does reasonable doubt actually mean? What is a moral certainty? What if I think she probably did it, like the last comment said? It's not guilty if she probably did it. That's really... It's so much easier for us to sit here and talk about and pontificate and, for people in the chat to say, I get it. It's much more difficult, especially when Hank Brennan turns it on with what a great human John O'Keefe was and how he's always helping people. It's a lot harder to look at his family and say, I think she probably did it, but I'm going to vote not guilty. So if you're Jackson, you have to implore them to, that is what the law is.
Because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that.
Not every jurisdiction has such a strong reasonable doubt to a moral certainty. Not everyone has such strong language. Florida's is not like that.
Must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw.
So on both of their closings, I'm going to skip some of the parts like this because I can't watch the full hour and 15 minutes, but I think I both have like 50 to 55 minutes we're going to watch together with each of these closing arguments. But we kind of know the facts. We know how they're both going to tell the facts and tell the story as they see it. I am more interested in how they are going to back up those facts with what evidence, what testimony. Do I think it's actually credible? Or did one side or the other crush the credibility of that witness or that piece of evidence? I want to know. Tell me how you proved that if you're the Commonwealth. Tell me where you got this information or why I should believe you if you are the defense. That's really important, and that's what we're going to stick to. And the defense did a lot of that. They start to get into Higgins had eyes for Karen, and that becomes important later. And he starts showing you what it looks like to argue the Bowden defense hybrid with a third-party culprit, which to me was always the better defense in this case than just pure third-party culprit. We can prove Brian Higgins did this because they can't. They can't. They didn't prove it. To me, I should say last time, that was one of the struggles watching it. They didn't need to this time. They created it as an incredible piece of reasonable doubt due to the fact that the cops never investigated Higgins enough for us to ever really know that answer.
Not Karen ever arrived. Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well?
So do you see what I mean by when you're telling the story, when you're telling me a story, tell me the evidence that backs up your story. The jury can look at the text. Now, Jackson's putting his spin. He's arguing. He's saying what he thinks it means. But he is telling the story and saying, I'm getting this from the text messages from Brian Higgins. That's what I like to hear in a closing argument. Weave the evidence into your story and your theory.
We got no response. And then we see this. That's what Brian Higgins was confronted with following his well text.
That's the kiss on the forehead, I believe.
What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
So we're going to have to wait till tomorrow for me to fully break down Brennan's closing. If you guys ask questions, I'll still answer them during this one, by the way, about Brennan's. But this to me was maybe a bridge too far for Jackson. Like, I loved everything he said about, but they didn't care enough to investigate him, right? But this, I actually thought Brennan put a better spin on it to say, so he's practicing to kill John O'Keefe later? Because I don't buy that. I don't buy that this was in. Jackson saying that's the mindset. That's what he's getting ready for. And maybe it is what happened. But I think the best argument is we will never know because of Proctor and his band of misfits in this case. People are saying the lawyers are heading back in. So let me know as soon as they are, and we will jump to that.
Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored.
That's the argument. They completely ignored. Doesn't look like they're in the courtroom yet on court TV. We will head back there, though, if they get there.
Higgins.
The jury has a question already. Is that what they said? Oh, I heard the jury has a question. We will go back to the courtroom as soon as they're there.
Is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look.
Good vibes, Stacy. Yes, we're keeping an eye on the courtroom. It sounds like the jury has a question. Everybody's going back to the courtroom. We will go there too when the feed is back up. Why did the defense go first in closing? It's a great question because I said the Commonwealth would go first and last. That's how it is most places. Not in Massachusetts. I forgot. I remember this happening now last year. The defense goes first. Jackson gives his closing. Then the Commonwealth goes at the end so they get the last word because they have the burden. And I see everybody saying, I think Jackson did a great job using the video to tell his story. Absolutely. I just think they didn't necessarily need it. I like some other arguments better, but I am nitpicking now to what I thought was one of the best closing arguments I've ever heard in my life. Literally one of the best I have ever heard. The fan is on. The fan is on. Yes, we will jump over there as soon as they're in court.
But he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks.
Somebody said they're sending the jury home. That would be kind of a buzzkill, right? But not surprising. My kind of thought with this was they would look at things preliminarily today. They'd really dig in Monday. Even if they had a verdict by the end of the day Monday, they probably want to go sleep on it, come back on Tuesday, potentially. I certainly don't think there's a verdict right now. I'd be shocked. Somebody said the jury might want to go home. That to me makes more sense. We will jump to the courtroom as soon as it's on the feed.
Toward the house about 5 minutes before Karen sees him alive for the last time. So what happened inside that house or that basement or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling.
I absolutely loved this. What did they ignore? And you run through all the reasonable doubts. Matthew, make a completely uneducated guess about what the question will be. It makes sense that they want to go home. That would be my guess. My guess is they're asking if they can just go home for the weekend.
falling backward onto a hard surface, alleged surface. A text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't.
She connected to his Wi-Fi at 12:36. He makes sure the jury knows that because he's going to hit the timeline. That changed with the aperture witnesses in the middle of this trial. In the middle of this trial. Book Mama, that sure is interesting. That sure is interesting.
Respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m. when Karen...
So I'm going to jump ahead just a little bit. He starts getting into the science, talking about what Proctor screwed up, how bad he screwed it up, and we're going to get there.
I struck John, period. The science, it's an old saying, is known as the silent witness. It doesn't lie.
I love that saying. The science is a silent witness. It does not lie. It can't be manipulated.
It doesn't forget. And notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that...
Don't miss this, guys. And this is, if you're annoyed at how much I'm pausing, this is kind of what I'm doing. And I'm trying to put lawyer brain on here and explain to you how epic this is. He has so many details and so many issues he can talk about to do it in a streamlined beginning, middle, end. And by the way, he's not reading the whole thing. He's checking notes to go down because he could probably go on 50 rabbit holes and take an hour on each rabbit hole. Okay. He's not. He's going one by one by one. And when he gets to the science, he's going one by one and weaving in each one of the witnesses, showing what they prove that's good for his case. And it's easy because there's not really many that proved anything bad, but he has to say that too. He's doing such a good job weaving together so many complex details in a simplified version that is significantly better than his his closing on the first trial, in my opinion. Okay, so you can see here, they're not quite back in court yet. I'll put it up here so we can know this is live. They are not in court. It's going to be impossible for me to find where I was, but I will try.
About 5 minutes before Karen sees him alive for the last time. Established that it is impossible for John's sweatshirt sleeve to be damaged by an impact and have a bruise.
Shouldn't have done that. So you guys let me know when they actually get in court so I can jump to that.
So let's start there. I want to take a minute to discuss there was no collision. Was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact.
You know what's kind of funny? I noticed so many. By the way, I pulled up a second feed of the Law and Crime feed that I'm letting play in the background, so I'll be able to see when they come in. That's number one, so we won't miss it. Number two, do you know how many of the titles of my video or the titles I heard in both of these closings? Somebody said Hank Brennan called Proctor the boogeyman. He must watch the channel, which I thought was hilarious. That is hilarious. When he called him the boogeyman, I was like, he is the boogeyman.
At sight. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one.
And by the way, when you're going through the details and choosing what details you're going to put into your cross, you better not miss the big ones. You better not miss the home run swings. And that is a home run swing, and he weaved it in perfectly. Perfectly. Okay, here, let's get into Scortibello. You'd expect to see it. But guess what? No medical expert said on either side that these are consistent injuries with being struck by a car. This case should be over because of that. I don't get it. I don't get it. And it's not going to be a surprise where I think this one should land. Okay, some trials it is. Maybe even on the last one, it was a little bit different than this one. Still felt it should have been not guilty. This one is an abomination if it's guilty. There just was not enough evidence. And if there was, it's because people, here's what I think. If a juror votes guilty, they feel like they need to get justice for a cop, John O'Keefe, who seemed like a good man, whose family is there, incredibly tragic, incredibly sad. And it's like, maybe she did hit him. Probably she did hit him. It's more likely than whatever else would have happened here. So we're going to convict, which just, in my opinion, does not follow the law. And I know people are going to disagree, and that's fine. We can continue to talk about disagree. I'm telling you from my mind how I see it.
One. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own expert said
it's cooked. The case is cooked, folks.
There is no evidence of a collision. No evidence.
They said the jury skews younger. I'm definitely using words like cooked in my closing.
Of an impact. If you want to know what an impact looks like, take a look at this.
Oh, how brutal for the Commonwealth. And did we know they were going to do this? Did we know that they were going to use Welcher's own example against him? Did we know that? Did we say that? Did they need to? 100% to give me a test case that looks like somebody that got hit by a car that I can use to absolutely differentiate with my case. Oh, it was just so perfect. And he weaved it in perfectly when talking about Scortibello and the medical experts. It doesn't matter that it was Welcher's example because it perfectly is presented right at this time in his closing argument, in the outline of his closing argument.
This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? that silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rinchler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent.
And I thought they should and did use that. And he mentions it in closing. It's incredibly important. It's just so unusual. You can't let it go. The Commonwealth let go of a couple advantages they could have had, like rebuttal. The defense is not going to let go of this advantage that an independent third party initially hired ARCA.
They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm.
All right, we are pausing. Court is back in session. So I have to remove this and pull up the other feed we have here. And let's take a listen to what's going on in court.
I understand you want to go home. It's been a long day for us. All right, jurors, I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. See you Monday morning, ready to start fresh. Thank you.
All right, no surprise. The reports were correct. I'll keep that up just in case. I'll keep that feed up secondarily, but it does bring my stress level down a little bit that I don't have to watch two streams anymore to see if they're going to end up in court. That you really shouldn't get any indication from that. Except that I guess if you want to take something from the jury going home, they're not going to immediately come to one or the other, which I saw, and I might as well hit some of these questions now. Michelle said, did you see that? Whoops, hold on. Did you see that they added lesser included number 5 OUI? I did not see that. Interesting. Maybe the defense, like I've been saying, the thing that would scare me if I was them is a split the baby type of verdict. Maybe the OUI is going to give them that. Bev said, if jurors in the first trial found the verdict form confusing, why include 7 guilty options and only 1 not guilty option this time? Seems crazy. I don't know that that's what it is. Only 1 not guilty option and 7 guilty options. But I did listen to Cannoni say each individual count has 1 charge. When you all vote unanimously, check the box, sign the bottom, then move on to the next. I thought it was better, not as good as the defense is. We'll break that down another day if these deliberations continue. Matthew said, been keeping a low profile. What a saga. So proud of my coworkers, including my boss, the Crash Daddy. Thanks for helping keep me sane these last few months, Peter. P.S. We have a Florida office. ARCA and Tragos Law. Maybe they'll be teaming up at some point. I would love to. I was impressed, Matthew. And we've had some cases actually against ARCA as the experts on the other side, not Wolf or Rentschler. If the jurors decide he wasn't hit by a car, is that not the end of deliberations? If there's an OUI, then potentially not. I've got to probably at some point, I didn't want to. I hate listening to jury instructions in cases I'm not trying. Maybe I'll go listen to them at some point. Mego, Brendan, closing. Did I miss something? There is a video of Karen Reed's broken taillight prior to the police impound. Does that not seem like a huge evidence to folks? I hadn't seen that until today. He's played it and he's showed it. And he's asked people. To me, all of that is confusing. Like, both lawyers are going to look at the taillight and tell me it says what they think it says. That's not going to be overwhelming evidence to me either way. Personally, will it to a juror? Maybe. Why did the judge select the 4-person before selecting alternates? Would the 4-person be excluded from drawing for the alternates automatically? I would assume they take that one out. That's just how they do it here. I can't really comment on how I do it. It's so different than how we do it here. If she's acquitted, can she sue the Commonwealth? Potentially, if she can prove it up, but not automatically just because you're acquitted. Thanks so much for your coverage during this trial. from a fellow Tampa girl turned Texan. Do you think ever jurisdiction should have to a moral certainty? I would love it. I would love it. I think it should. It makes sense if you're going to take somebody's life and liberty away. I loved how AJ contrasted reasonable doubt with likely, very likely, possible, and probable. And then Hank Brennan comes through with, this is viable argument, chef's kiss. Is it typical for the defense to close, then the prosecution? Not in my experience, but that's how they do it here. Or just the Commonwealth. Thanks for your commitment to unbiased education about our judicial system, making a difference. Lawyer, you know. I appreciate it, and I love when you guys reach out and tell me. It makes me feel great with all these hours and all the time spent with how you guys enjoy it, learn from it, become better jurors, and understand the process better and have less fear of the judicial process of the country you live in that affects your life. I love that. Do both parties know in advance what the closing arguments will be? No, they do not. Speaking of that, let's get back to Jackson's closing.
And John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project.
You knew that was coming. And listen, this is Jackson's personality. I didn't really talk enough about it off the top because there's so much I want to get through. But this is where Alan Jackson shines with the speeches. Get out of my, it's like the isolation offense in basketball. Everybody get out of my way. Give me the ball. Let me cook, right? This is what he does. This is his type of personality. These happen to be my favorite parts of the trial as well. This is where he cooks. This is where he's going to take subtle shots when he needs to, like the kindergarten finger paint competition. You have to be careful not to go too far. But again, that's why you guys, the chat and the public, are so important. You can take the temperature of the room. Read the room. The public watching this case helps him read the room, know what buttons to push, know where the pressure points are. And he did it masterfully here. Masterfully. Just enough snark, just enough anger, just enough like getting up on my soapbox. This is not how it should be. Just enough of that, but so much pointing out how the evidence proves reasonable doubt. It does not prove guilt.
He did lab testing. He did field testing. He did data testing, actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Lee Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at 1.
Again, this is where he's going to tell you the taillight says what I say it says. It wouldn't light up if the diffusers are broken. The jury's going to trust their own eyes, in my opinion. They're going to look and listen to what the lawyers say. Both lawyers are going to tell you, this is my hand. I'm going to tell you what it says. I don't find it overly compelling, personally. John said, I expected Jackson to come off more aggressive. He toned it down just enough, John. I agree. Sometimes he can be too aggressive. Sometimes he can do the wind-ups and the questions that I think is inappropriate that you shouldn't do. I do see it differently as a defense lawyer and a prosecutor, but I thought he mixed it perfectly. People are like, oh, you're glazing Jackson. I like watching good lawyering. I'm not going to apologize for it.
Joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise.
Bang. You can manipulate a taillight fragment. You can't manipulate a bruise. Definitely throwing shade at the conspiracy and all of that. But the point is, what I'm hearing as the juror like me, who I don't think they proved the conspiracy, right? Is it logical? Does it make sense, especially with the Procter Glass thing? Sure. They didn't prove it beyond a reasonable doubt. But that type of shade, I'm like, you know what? I may have questions about the taillight. How did the taillight explode? How did it not? Did it get to the diffusers? All of that. Like, maybe I have some questions about that. But why was there no bruise? The Commonwealth has no answer for that.
If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue.
I mean, you got to remember, I'm from Florida, folks. I didn't have to pay for this trial. I got to pay for plenty of other ones that have wasted time and things like that. But he says $400,000 of taxpayer money to paint your arm blue. These people are taxpayers. We've got a lot of Massachusetts people in this chat. How does that make you feel? Does that prove reasonable doubt? No. But will it make some jurors angry? Is he playing to their emotions there?
Which told you exactly nothing. The ARCA test.
That was an evidence that it told him exactly nothing, thanks to Hank Brennan, frankly. Melissa said, if the jury says not guilty, can Bev overturn it? No. She can actually do the opposite, I should say, in most jurisdictions. The judge can say, if the jury votes guilty, they can say, no, there just was not enough here, I'm going to throw it out. But they can't take a not guilty verdict and turn it into a guilty verdict. Yeah, we went back and we watched court. It was just the judge letting the jurors go for the day because they wanted to go home.
Testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes?
And once again, this is what I'm talking about. Marrying the evidence and testimony or lack or missing parts of it with your theory and the story you're telling. So you're telling me that the light couldn't, and remember this when we get to Brennan's, Jackson could have just said the taillight couldn't have caused the damage to the arm and moved on, but he didn't. He said the taillight couldn't have caused the damage to the arm. Here's why. They testified that smashing the taillight like that would have smashed the arm. The 36, injuries on John O'Keefe's arm don't match the holes in the sweater. And they went through and showed how the evidence proved the point they're making in the story they're telling. Okay? It's very different than some of the part. Now, Hank Brennan had kind of 2 parts to his closing, but when he was telling the story, he was kind of just telling a story. Felt a little like an opening statement at parts.
That. Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouge.
Notice how he said canine teeth too? Because it's like, I'm not going to say dog, I'm not going to say animal. I think we all know what canine teeth meant.
Into John's arm. That's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth.
It's like you had that hair that stuck there. You had all this other stuff, but just none of it stuck on the taillight where it scratched him and gouged him enough to make him bleed. So Alexander, this case is tech stream cell phone data versus medical collision reconstruction data. I like what you said there. I don't disagree with it. And you're touching on some of the stronger parts of Hank Brennan's close from my perspective when it got to the timeline and the data. But if they cannot remove these reasonable doubts, just because the timeline matches up to where, like, that's probably how it happened. The law says it should be not guilty. That's how I read it. You can disagree as a juror. Let me know. There is, in fact, only one not guilty option. Gosh, I've got to read through this again now. I guess I have to look at the jury instructions. I got to look at them.
Cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens.
I mean, that's literally Brennan and Welcher said that way too much. And again, we all picked up on that. We all talked about it. Christina Rex shared the verdict slips. Will you go through them with us at the end of today? It does include OUI. So probably not today, but tomorrow morning, bright and early, probably somewhere around 8:15, we are going to do Hank Brennan's closing argument. I will try to do it then. Remind me then. If Karen Reed is convicted on appeal, does she have to pick a key point or list all of the appellate points? Example, Unetti's focusing on the verdict form. So you can have multiple issues you appeal on. Multiple issues. You don't just have to have one, but usually you don't pick every single issue that came up in the trial. What did you think about the jury final draft, juror 6, the one with more notebooks? He was out. That's sad. That sucks. Person that's just taken notebook after notebook for all these weeks, and they're like, thanks, but no thanks. It's brutal. It's part of the system, and it's necessary, but it's brutal.
That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck. He was immediately incapacitated. He was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also.
Now, that's disputed, but at least he's bringing it up. No, Tracy, it doesn't. That's the point, right? That's what's important. Ashley, thoughts on AJ not spending more time on Karen Reed connecting to Wi-Fi? I thought he was going to hammer it right here. That's where I thought he was going to hammer it. With the crash time, anything else you would have added, changed? That was the big one. That was the big one. And frankly, I might have done less Higgins, more ARCA, more medical experts, more Dr. Russell. He just kind of touched on the dog bite stuff. But again, we're nitpicking. This was really good. Peter, thank you so much for your coverage of this case. You're unmatched in my opinion. Also, we're twinning today. I have my tie-dye LYK shirt too. That's got to be good luck, right? I saw a bunch of people posting this, so I decided to put it on for the stream and hang out with you guys. If you're wearing your tie-dye Lawyer You Know shirt, let me know in the chat.
That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess?
We all know where this was going, right? Poor Mr. Burgess. We all know where this is going.
He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV.
I mean, here's the other thing that's really good about Jackson. It's like he brings up these haymaker points and he's just like his CV, and he tells you, and just the look of disappointment in his eye. And he says it a couple of times. He's like, that's really unfortunate or really sad or really disappointing. Oh boy, AJ is the Halliburton of law. This might be some fighting words if we have some OKC fans in here, or Knicks fans, or anybody else the Pacers have smashed throughout the playoffs.
To answer that question, that was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen.
All right, I am going to do something real quick. I'm going to refresh so that I can get my timestamps back on, which is just brings joy to my heart that I can get to proper timestamps.
Back. Adolescent.
All right, we've got that back because when it's live, it's just so much harder for me to do. In case you didn't notice, he talked about the battery. They both kind of used the battery temperature to prove he was inside or this is where he was. But again, nobody really gave us enough evidence for that to be locked and loaded the truth, which again strikes against the Commonwealth because they're the ones that actually have to prove this to us. He explains how it was not hypothermia. Everyone agreed that it was the fall back, hitting his head. All the doctors agreed. What could cause that fall, right? Could a fight, things like that. Rearward fall. Yeah, that's the PowerPoint that he made. Why did the judge pick the four-person? Is this normal practice? Sorry if asked already. It's what they do there. Did you like the shade AJ threw at Brendan about the hoodie trickery? Who needs a jury instruction? We're going to get there, and we're going to talk about how important that was. I believe Karen Reed is not guilty. I was a juror in Massachusetts, so I've been following through that lens. Do you have any concerns that J.O.'s mom was emotional in front of the jury on Brennan's closing? I think that's some of Hank Brennan's best evidence or mojo in this case is the sympathy, is the justice for a fallen police officer. Hi, Peter. Is there a way for the defense to appeal a judge's conduct in court? Why does the judge not throw this out? Thanks for your content. It can be part of their appellate arguments. Can you explain what document was submitted this morning? I don't know what document was submitted this morning. What are your thoughts on Brendan taking the look the other way in his closing argument that Jackson used in his last close? Huge cringe. Love the show. Tell wit. Go Sharks. Oh, do we have a Riverview High person in here? Totes my goats. I will tell her there or that. Somebody tagged me on Twitter of the side-by-side. Weird flex. I'm not sure what I think about it, honestly. Shoulder bothering you, Peter? Did a taillight bite you? No taillight, just old age. I'm getting old. Any ideas on the hot mic this morning and what the Commonwealth was mad about? Seems like they got their way on all the arguments from yesterday. I did not see the hot mic moment. You guys send it to me if you want me to. I'll break it down tomorrow maybe. When all this is over, you're going to try to get AJ to do a live stream with you. That would be awesome. We'd probably have a lot of fun. I usually don't reach out unless I know them personally, which some of the lawyers I have and had them on. I usually don't reach out. They're doing so much. They're probably going to be doing so much press, win or lose in this case. So many different things going on. They're so busy. I would love to have them on. I think it'd be incredibly fun to talk about the case with them. Does the jury go home for the weekend mean they have a verdict, just don't want to look bad? I highly doubt it. It probably means they all sat down. Maybe they took a preliminary vote, maybe not. But they said, listen, we're not going to get this done by 5 o'clock today. Let's come back Monday. Peter, if you were the judge on this one and the verdict was guilty, would this one be enough to overturn the verdict? It might be for me. It really might be. Bill Langlois, are you Greek, Bill? Peter, what is the likelihood that unsequestered jurors in cases like this go home and don't discuss the case online? Unsequestered? Realistic? Does court assume they might? Does court closely monitor this? So they don't necessarily closely monitor it, but they might try to monitor it, especially in high profile cases. The lawyers may have teams monitoring it. If they were a alternate that's now oh, you mean unsequestered, like meaning not staying in a hotel, like actually jury sequestration. The likelihood, I don't know, man. I always think, how do they not? But I hope they don't. That makes sense. All right, let's keep listening.
Laceration to the right eye consistent with a fist or a punch. And you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPrasada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out.
So they asked all those questions about the the step and the ridge and the concrete floor. They didn't necessarily get to get that into evidence. Michael Proctor never went in to take a look. By the way, I don't know if we ever heard about the garage. Thought it was the weight room. That is what criminal defense work is. Maybe it was the weight room. Maybe it was the garage. We don't know, but they can't prove it. That's the point. Michael said he can't get past the fact that there was no movement from John's phone when they allegedly brought him out and planted the phone near him. It seems like it never moved from that spot. I agree. That is suspect. That is one of the questions I have as well. How do you answer that if you're the defense? How do you prove his phone moved? But we're asking ourselves the wrong questions. The Commonwealth needs to prove to us that he was hit by a car. And you can have questions with the defense's theory. I have questions with their theory. I have questions with the third-party culprit. I have questions with the conspiracy. But they don't have to answer those questions. Now, maybe online and for people to get up in arms, and that's fine. That's fine. If people want to answer those questions and they feel confident in those questions, I don't. But I know legally we do not have to answer those questions publicly as the public, and the defense does not have to answer those questions for this jury in order to get a not guilty verdict.
What a shame.
And I like that. I like that moral high ground being like, that is a shame. That a cop, a lead investigator, would not even take the time to go look in the garage or look in the house because it's a Boston cop.
And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had him. You don't
love that. You don't need the top experts in the country, but you had him. Just look at his arm. Do you think he's following what the public says? That common sense and logic tells you that's not a car. Most people, when they first look at it, say it's an animal. I think people said ChatGPT or something said it looks like an animal.
You need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equal.
So he said a single medical expert, they couldn't find one. Nothing. Look what they didn't do to you. We showed you and explained to you how this was a dog bite. Touche, Larry. And they couldn't bring anybody. And he said medical, which was powerful, which was correct, which is making sure that you're being honest. But he said medical. What do you think the jury heard? I feel like the jury heard no witness because they didn't call Crosby. They didn't call a DNA person to talk about lack of dog DNA. Did Brennan even say lack of dog DNA? I don't even remember now. I'll have to listen to it again. But when he says no medical witness, which is correct, I think some of the jurors heard no witness, period, came and said this was not a dog bite or scratch. Did they eliminate that as a reasonable doubt?
Equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan. Did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times.
He chose the quotable moments in this case. And he's going to talk about Dr. Russell, acute grief syndrome. He hits the key points and quotes in this case. And it is so hard because there was so much. I can't tell you. It's almost like the more you have, sometimes the harder it is to do a closing argument. And I promise you, I shouldn't promise you because I don't know Alan Jackson. I don't know his personality. I'll just say for myself, if I would have delivered the best closing argument I ever could in my life, I still probably would have left and been like, oh, I wish I could have worked this in, or I wish I gave that analogy a little bit differently. When there's so much, sometimes it's very difficult.
3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden.
So he talked about how Scorty Bello was, it's inconsistent. Some of the other witnesses, it's inconsistent. Then he gets to the witnesses that were even stronger. Didn't happen. He didn't get hit by a car. Kevin, thank you. Let me answer a couple questions here. Why would a judge be able to overturn a verdict after a jury decision instead of just doing a directed verdict of acquittal before deliberation? So I will tell you, you make a very logical point, but sometimes it happens. You want to know why it happens? Sometimes judges don't want to make certain decisions. So they're like, maybe the jury will just acquit. So if the jury goes and acquit, it's not a judge's decision. But if they convict and the judge truly believes that there's no reasonable jury that could find for guilty and something happened and made them vote guilty, it can happen. It's very unusual, but it can happen. Sometimes they don't do it prior to deliberations because they just hope maybe I won't have to make this decision. Peter, how many days are you thinking for deliberation? I've kind of been thinking probably Tuesday, early Tuesday. I was thinking maybe they make their decision late Monday. They want to sleep on it, come early, but I'm just making that up. Frankly, you don't really know. Do jurors get a recording of closing statements? No. No, they do not. One not guilty option was argued after the jury sent to deliberations, FYI, Peter. Huh. Okay, I have to take a look at that. I thought she wanted them to deliberate till 5:30. What does leaving early mean? That they want to go home for the weekend, and they probably know we're not going to get a verdict today. And she can want them to, but usually the jury rules. Usually the jury rules. Oh, Peter, I'm praying for Karen. I could not listen to Brennan. His banging was awful. He comes across like a real shyster. It made me so upset. Wearing my Lawyer You Know t-shirt for hope. We're going to get to Brennan tomorrow. Tomorrow morning, bright and early, we're going to start our Saturday with Hank Brennan. Bev said something about requesting extra security. Is that a bad sign for a normal or normal for how I profile the case is? She just probably wants to be, safe, which I don't blame her. Anthony said the foreman took 0 notes. Oh boy. Oh boy. Now, does that mean he made up his mind early? My dad has some thoughts about that you'll find out on Sunday. Peter, can you break down how much time comes with each charge? You mean like as far as sentence goes? We'll do that on another video. I think it's up to 20 years for involuntary manslaughter. I'll have to look because I don't know them off the top of my head, especially in Massachusetts. So I'll have to look. Let's listen to a little more here.
The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast.
I mean, that's like, boom. No medical experts. And then he mentions their own medical experts, but they didn't say he was hit by a car. How are we here? I really don't get it. I don't get it. Like, that doesn't matter at all. Ben and John, that doesn't matter at all. Sure, OUI, if they find her guilty of operating under the influence, fine. I think there's some issues there, but I can understand why they'd vote that. But I guess for John and Ben, and there's more than that, people in here that think that she's guilty and would vote guilty. The timeline, is it the timeline you just can't get over the fact that phone is there, car is there. When the backup happens in the car, phone stops forever. I can understand that. I can understand that. But how do you get over the medical evidence, right? It does feel a little bit like phone data and Lexus data versus medical evidence and the science of the accident reconstruction. Those are the juxtaposition to me, just too strong of a reasonable doubt. I understand how the timeline works, though. I do understand that. This is always my favorite. He's a civil lawyer. This is always my favorite. Always my favorite.
That with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there, no matter how big a check you write. There's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car.
Okay, I like this. I appreciate this. 53 calls, but not one to 911. And I will tell you, there are some things in Hank Brennan's closing where I was like, that is suspect. That doesn't make sense. Why did Karen Reed do this? Why did these people do that? I asked myself multiple questions like that during Brennan's closing. So wait till tomorrow, because there were some points made, absolutely, where I was like, man. But we've got to remember who has what role and who has what burden. And if you don't remember it, if you weren't reminded it and taught it during Jackson's closing argument, then I think you just see it differently, right? Mother Teresa says guilty. If you could, you don't have to, but if you think she's guilty, tell me why in the chat. And the chat that disagrees with that, let's have open discussion and not jump on each other. Because I want to know what sticks out as most important. As most important. I'm going to jump ahead a little bit here just because we don't have time to listen to everything. Then he starts to get into the failed police investigation. They didn't secure the scene, didn't treat the house like a scene, didn't do their job. He points out all the evidence he believes to be consistent with a fight. Again, that's less compelling to me personally than the reasonable doubt argument, than, proving that there was a fight inside the house. And then we get into the Proctor texts.
This was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you want.
And I think he's going to do a good job here with the texts. I think they were probably more powerful trial one. So I will tell you, there's also a part coming up in this closing where I can say maybe I've changed my mind. Maybe Jackson has convinced me differently. I still feel like calling Proctor may have been a good thing. I can understand why they didn't, but there's something that he worked in so well with the timeline, so well to prove the theme and theory of what he's trying to go with, that I'll stand corrected. I'm not above that. More information can help you change your mind. You guys have been saying it. I've been thinking about it, chewing on it, and maybe I could have come around.
But here are the highlights. Proctor starts the conversation. Quote, all the powers that be want answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that.
And here they go. And the importance of that is he said it and when he said it. Peter, who planted the glass shard from OJO knows that Karen Reed admitted she pulled out? I don't know. Does that prove he got hit by a car? Like, where in the physics, how does that work as far as getting hit by a car? Like he was holding the glass here? Because if he was holding it here, Welcher didn't give us an example of that, where it could have hit him and how did it land right, in the same vicinity as him? That doesn't make sense. None of it makes sense. I agree with you. So many unanswered questions. None of it makes sense to me.
Hours into this investigation, there will be some serious charges brought on the girl.
I got to be honest. To do that in a genuine way, to shake your head like that in a genuine way is harder than you may think. It's harder than you may, like, you have to really feel it. At least me, I can't fake stuff like that. I'm not good at faking stuff like that. I'm not good at kind of like putting on as a character. Some people may think I play a character here on this channel. It'd be really hard to play a character for like 2 hours. But, oh, by the way, we're at the hour mark, which is the time to hit the like button, folks. Everybody hit that like button. Kelsey, go ahead and throw the poll up. Yeah, we do polls usually during closing, so go ahead. Guilty, not guilty, hung jury, or guilty of a lesser included. Go ahead and throw those 4 options up. You guys can vote, and we'll talk about it a little bit as well. But everybody hit that like button.
And up to this point, Michael Proctor had done 0 investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same.
I mean, without all the, science, that's enough for you to make you go, And that's why it doesn't need to be a big conspiracy. It doesn't need to be a fight and whatever for them to have planted evidence or moved stuff around or forced the issue to make sure people want answers. There's going to be charges and we're not going to give the homeowner any crap because he's a Boston cop. That's enough for cops to just be like, we got to make sure we get this girl. It doesn't have to be a big conspiracy. Now, it could have been. It doesn't have to be a fight inside the house. It could have been. But he's giving them multiple ways to get to the conclusion that he wants them to get to.
Same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this?
Ooh. He's like, they gave all the information to Scorty Bello, and she still couldn't determine that he was hit by a car. That's incredibly strong. If Massachusetts State Police can't trust Proctor, how can you? And remember what I said about making sure the jury knows the Commonwealth and Michael Proctor are like this? A vote for the Commonwealth is a vote for Michael Proctor. They're on the same team. That's coming.
This investigation and with your verdict and with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired.
It's very similar to how we said we would do it with Michael Proctor, right? I mean, hats off, because he's bringing it home. He's tying it all together. And the way they look at Proctor, right? How much better was this argument than, well, if the person is favorable to the Commonwealth and available to them and all these boxes you have to check before you can have a negative inference, forget about that crap. Let me just argue my negative inference. I'll convince you. I'm the lawyer.
This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact.
And that's a big one. I know for John O'Rourke, he's mentioned that multiple times, and I agree. That is a big one. How would the taillight shards get there? Jackson gives an explanation. Is it good enough? Maybe not. Maybe not. But do the shards alone prove that contact and collision with the vehicle to break it all the way down to the diffusers?
What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well.
He barely even talked about it. That's how much they have. He barely even touches on the red solo cups and the Stop and Shop bags. And that's one of the things where that might be a little bit of fatigue because we've seen that so much and talked about it so much that it wasn't even a big enough point to make it an hour and 15-minute closing. But how wild is that they use red solo cups?
Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA, where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog.
Because it was a dog. Right? Getting loud and softer, explaining your theory. a little bit of sarcasm, a lot of force, a lot of disappointment, right? Grandstanding, which I don't mean that negatively. I mean, like, we're lawyers. We stand for justice and what's right. And what happened in this case is not right. Shannon, I agree. That's a question. I don't get it. I can't explain it. The Commonwealth needs to explain it. Explain to me how that proves a collision occurred. Nobody on the Commonwealth's team, including the witnesses, explained to me why that proves a collision occurred. They proved to me that that kind of creates questions, and it does create questions to me.
Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing, not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard.
To be able to make that point in like 1 minute or 2 minutes maybe is really masterful. Like it was in, he's in and out, just make a little point, just another checkbox of very strange things going on in this investigation. That's well done.
The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together. The only two things that go together on that bumper are the Proctor glass.
I probably would have thrown up my chart because it was such a beautiful chart that he made. The questions like that, questions like this, questions like the glass in the nose, the Commonwealth is the side that has to answer your questions. Be careful about thinking the defense has to answer your questions you have about what happened. That's why people, I think, get most annoyed at me, is I will always push that and say, Commonwealth, they've got to do it. Their job, prosecutor, they've got to do X, Y, and Z. The defense doesn't have to do anything. Ask any judge, they will tell you that. So all these questions you have that you're saying those questions make you vote guilty, I think that's a backwards way to look at it.
We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was...
All right, I'm going to jump ahead a little bit. He talks about how Lucky Laughlin and a bunch of people were just witnesses ignored for years, more bad investigation. Passenger seat of the Lexus was empty and John, wasn't outside. He kind of added some there. Nagel didn't necessarily say. They said they couldn't see. Somebody could have been standing at the passenger side. But, again, he's telling his story. They don't know when Karen Reed took her last drink. This entire argument, I get why they have to make it. I think, again, it's one of the weaker parts of their argument that she wasn't drunk based on her own clips. Sure, it's a good point. If this was a DUI case, they probably would have hammered this home that she could have gone home and drank, and how it puts a lot of reasonable doubt in a DUI case, which I guess there is a DUI charge or OUI, same thing. What happened when she got home and she was mad that he left her? Did he drink? If this wasn't a cop, it would have all at the house, the Albert house. If it wasn't a cop's house, this would all be different. Favoritism. Every one of these is a reasonable doubt. The Commonwealth didn't do their job. They're asking you to do it. Brian Albert had the German Shepherd. Jen called them at 5:07, right when Karen was searching. Proctor didn't get the phones. Proctor didn't investigate the dog. Then the dog disappeared. Matt McCabe told them to say, the guy never came in the house. Jump back in now.
Whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it.
And again, that can be read as that's the truth. So when you tell them that, this should be over. Kind of like when you prove there's no collision, this should be over. So maybe they were saying he never came in. So this should be over because he never came in. Or it could be a conspiracy. It could be a cover-up. It could be lie to the cops. It could be protect somebody.
With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Cellphone at 2:27 a.m. A Google search that read, Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m.
I really disagree. It's definitely contested. It's definitely disputed. I guess maybe that is deleted. Was it user deleted or not? There's definitely disputes around that, but this is closing argument. This is where you get your chance to tell the story. Mallory, I'm confused. Do civil lawyers go to a different law school? Also, Peter, I stated he was a prosecutor. Yes, I prosecuted cases, defended case on the criminal side. We still have a full case list of criminal cases. I just don't really want to work on them. I like working on civil cases better. And you know what else the great part is? I could do a criminal case right now if I want to. There are clients in my firm I could jump on and go try our next criminal case if I want to. I love it. It's so funny. It's great to talk through these things and try to understand. Like Brennan made a good point. It's like when you can't attack the data, you attack the man. Bring it, right? Bring it. It is hilarious. The internet is a hilarious world for what people do behind, fake names at their keyboard. And it's like, my face is out here. My name is, everybody knows who I am. You can look me up. I'm out there. TragosLaw.com. Look it up. Tell me what you think. It's like, I'm not trying to hide behind anything.
AM timestamp is not true. Why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses. Lying and perjury and admitting to it. A fundamental tenet.
Not sure she admitted to committing perjury, right? I get where he's going. I get the inference. A lot of them make reasonable inferences, but this is where he's, pushing the line a little bit. And if a jury hates you, they're going to be like, you're a jerk. That's false. If they're with you, they're like, yeah, she perjured herself.
Any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was, in real time, she was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling them everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have.
That was strung together nicely. And Dr. Russell with the assist here. Speaking of Pacers and 6.
Sergeant Buchanan also testified that the only statements Kieran Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video. It's not on audio. It's not in a single police report. It's not in a single EMT or EMS report. Nowhere.
Again, and the Commonwealth will say people did. He talks about how, we'll just play it.
The fact is, Karen never said, I hit him. You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check
That was pretty compelling, right? It's pretty suspect of Jen McCabe.
on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions?
All right, before we get to the next part, let's answer some questions. Victor, was Karen Reed ever tested for BAC percentage? They did do an extrapolation. I can't remember what it was. It was very high when they extrapolated it back. There were issues with it, but if a juror wants to vote, there may be enough there. Aren't the first 12 jurors picked the ones that stay? No, that's how I do it in my court in all of Florida. We have done in other states that do it a little bit differently as well. And the 6 extra ones that go, who decides who goes? So we pick alternate jurors in most of our trials, but here it's done by random draw. Am I wrong for muting during Brennan's close because I knew what he would say over and over and over again? I mean, a juror shouldn't mute it, but you're not a juror, so you can do whatever you want. Question, if Karen Reed backed up rapidly and scared John O'Keefe to move and fall, bash his head, would she be liable? In my opinion, yes. Have we confirmed that they added a spot for not guilty for the jurors this time instead of just having them not check off guilty? I believe the answer to that is no. I'm going to look into it, and I don't know if I'll be able to, just to be honest with you, between tonight and tomorrow. It's a holiday weekend, trying to do stuff with my dad, with Whitney's dad. So I don't know how much time I'm going to have to really look into this stuff. If you guys have it, send it to me. Katie, Peter, my dad and I truly enjoy watching your coverage. I bought him a Lawyer You Know hat for Father's Day. Could you please wish him a happy early Father's Day? Happy early Father's Day to Katie's dad and to all the dads that watch or have somebody in their family that watches The Lawyer You Know. Proud dad here as well. My favorite things on the planet outside my wife are my 2 kids. When will the gag order on the lawyers end? Can they talk now? No. Or does the OUI charge mean she can be found guilty of just drinking and driving? Also, hot take, Lally clothes over Brennan clothes. Ooh, interesting. Yes, I believe so. I need to look into those, to the verdict form more. I need to look into the verdict form more. Where can you get the verdict slips to read? They said on Twitter. Hi from Germany. I am this shocked this mess of an investigation was even allowed to get in front of a jury. Why did nobody request a proper investigation, i.e. the prosecutor? It screams reasonable doubt. They should have. And somebody else commented that prosecutors should not take like cases like this and investigate them. And we've done that before. We've been like, this is so bad, dude. You can't even help us here as the cop. We're not filing this. It does happen. If hung, does the Commonwealth have to retry it within a certain amount of time, or can they decide to wait until they have a better case, more evidence? They have to retry it within a speedy trial time. I don't know exactly what it is in Massachusetts. I probably looked it up before the last one. I appreciated AJ's emotion at defense table after closing when he left everything on the field. Are you okay with the emotion being shown by lawyers if it's genuine and not over the top? Yes. Why can't the jury get copies of transcripts? I thought this was allowed in most states, if not all. I find it insane that if they ask, they're refused. This is different state by state. Different state by state. Peter, do you think the Commonwealth will try a third time if this ends in another mistrial? They shouldn't, but I think they might. What did that comment about one not guilty was argued already after sent to the jury mean? I think they mean I wasn't overturned and this is how we did it last trial, so why would we do it differently this trial? That's what I think she meant. Sweet and Salty, a.k.a. Rachel. Peter, we love your content in my house. Please give a shout to my husband, Tony. T-Bone. Happy Father's Day to you, Tony, and all the dads here in this chat right now. I never thought, why didn't Jen ever tell any of the cops on the scene to go check on her family? I'm still not convinced of what really happened, but not guilty for me. That was a great point. And Jackson made that point in closing. I keep saying cross. All right, let's jump back in.
Questions also about Brian Higgins. Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature.
That's why you just give on certain points as a witness. You don't fight everything because then it becomes, you don't want to be quoted in closing, right? Frankly, Buchanan wasn't quoted that often in closing, so maybe he felt like...
The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way?
Does it prove he beat up John O'Keefe and was angry and, he was practicing to beat him up in the bar? No, but it certainly raises questions, which is what defense attorneys do. I've said this a million times. But just Higgins' behavior after the fact, in some cases, would be what a defense team built their entire defense around. We don't, as defense attorneys, usually have all the stuff the Karen Reed defense attorneys have in this case.
Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if the report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that.
I listened to these, by the way. Me and my dad start Father's Day, right? We played golf early this morning and he was like, he can't say that. They don't have that proof. That didn't come in this trial. I was like, trial's over and they didn't get him. I think it's pretty reasonable inference that they're never going to get him. He's like, yeah, I guess good point. Me and my dad kind of helped each other change our minds on a couple different things today while we were playing golf, talking about this case for like 3.5 hours. And we talk about it in the podcast that's going to drop on Sunday, how both of us kind of changed our minds on some big things that we disagreed with earlier in the trial. Mine's going to come up here in a minute with Jackson as well.
And Michael Proctor never gave him a second look. All of that in the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt.
Why do you need a missing witness instruction when you can do that? Why do you need to call Higgins when you could do that? Now, destruction on the military base, butt dials, etc. But honestly, how would Jackson have fit all that into this cross? If he would have called Proctor, Higgins, all those guys, McCabe, Albert, how would he have fit all that into his cross? Naughty Knitter, as a nurse practitioner, I can't get past the lack of injuries in John's extremities, lack of DNA on shards, and unmatched glass on bumper. The timeline is good, but I still can't get past my doubt. So many medical people in the chat have said this exact thing. I don't know if there are any medical people on the jury, but that seems to be a consistent theme with medical people. People with medical backgrounds, I don't know.
The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together.
Here we go. Here we go. Michelle, I'm about to answer this question.
With the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moment that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton.
That moment, by the way, the clip missing from the Sallyport video, adding that context was huge for me because, again, they didn't really do that with Dever on the stand. Let's keep listening.
It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did
grand play directed by Michael Proctor? By the way, another great Dever point, which a lot of you guys said, compare and contrast between her and Barrows. I still don't think the way that she came off, I think I cringed. I'll just tell you, I cringed a ton for the defense when they were had Dever on the stand. But the way Jackson is weaving her into this closing, he takes about 5 minutes using Dever in an hour and 15-minute closing. That's significant. And the way he gets his theme, he gets to compare and contrast, juxtaposition, explain the difference, and use her false memory she created as more Higgins problems, reasonable doubt, and cop manipulation. I'm gonna let it play out the rest of what he has to say with her and then give you my thoughts.
Did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer?
So, sorry, I hate when I do this, but I put a thing up I want to answer. Projects with Grandpa Steve. Yes, but literally speaking, no. Like practically, everybody's throwing out their theories. If I was in the jury room and you threw that out and you're like, well, let's discuss that, I would say, no. The Commonwealth never once said maybe Karen Reed drove close to John O'Keefe, causing him to trip and fall. So don't forget. And by the way, it sounds like I'm yelling at you, Steve. I'm not. Or projects, whatever. But if the Commonwealth didn't tell you it happened and prove it to you, you can't go back there and say that's the theory you're going to convict on. You guys are asking questions like, hey, is it possible she drove close enough, caused him to fall? Sure, right. Anything's possible. That could have happened, I guess. But how did he get the scratches on his arm? Right? Why didn't Lucky Laughlin see him? Why didn't anybody in 34 Fairview see him when they walked out of the house? Still so many unanswered questions. In this case, the Commonwealth married themselves to their theory that John O'Keefe was hit by Karen Reed's car and the scratches on his arm are from the taillight. They are married to that. They have to eat that if they can't prove it. I don't think they could personally.
Absolutely not. Absolutely not. It was cracked, but not completely.
Sorry, I'm going to back it up.
When Michael Proctor
Pause right in the middle of, he's talking about Barrows now, still talking about Dever, kind of comparing and contrasting them.
picked up that SUV at 412. His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrow saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch.
Again, talking about the strongest evidence and not the strongest evidence, this is not the strongest evidence to me. I don't think did they even ask ARCA this time? Like if it backed up into the traverse, because I think Lally, crossed ARCA and proving that like that's not where the crack happened. I can't remember specifically, but I don't even know if we talked about it this trial. Maybe we did and I just forgot.
That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat.
And you guys all said it. You said this is what he was going to do. You said he was going to use it to show this police corruption. And in the timeline of events and the structure of the beginning, middle, end of his closing argument, he fitted in perfectly. I don't know that I'd say they needed Dever, but she was definitely a useful piece for them in building this puzzle. I will stand corrected. I didn't like how she presented on the stand, but I love how Jackson used her in closing because it's bad. This is bad. How she acted versus Barrows is bad. The false memory she created is good for the defense's case. And then how she proved the false memory, also good for the theme of the case. Jason, I would buy that Higgins was peacocking with the fighting position more than practicing for what he was going to do to John O'Keefe. So I think that's a good point.
Seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does.
Again, the way he can use that quote, I'll stand corrected. They used her as a powerful piece of evidence in closing. They absolutely did. Absolutely did.
That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turned out it was completely inverted, flipped backward, completely false.
Again, this trial, this didn't feel like that big of an impact. So maybe he didn't need to have it in here, but he doesn't spend much time on it at all. Hi, Peter. We love hearing your thoughts. Do you know why Sergeant Buchanan was standing outside the courtroom? Is he added security? Can only speak. Oh, I hope not. He shouldn't be added security, but he's allowed to be there. Maybe he's the new lead agent on the case. A poll with lesser included isn't good. OUI is on the lesser included. Okay, well, I only have 4 options, so I don't know how to do it perfectly. But last time Kelsey sent it to me, it was over 70% not guilty. And then, I don't know, somewhere between 5 and 10% hung, which leaves 15, 20% saying guilty of something. I mean, that's not no one. That's not no one. If she's convicted of anything, it's DUI, definitely admitted, but millions of dollars and more than 3 years of her life, not comparable. So if they thought they were going to win on DUI, they never would have done this. Peter, I wish the defense had used the brain surgeon's comment about slipping and falling. That's my reasonable doubt. I would have much rather had that than this Sally Port video. Like, I think that was a great point. But it also is kind of inconsistent with some of the defense's other theories. Maybe that's why they didn't do it. Curiosity, Microdots posted on X the graphic AJ used, putting up a reasonable doubt note card for every point he made. So I noticed he didn't, or I noticed he said it. I didn't see it because I was listening to it. And I always wonder, like, do you want to make it sound like a ton? And if you actually show them the stack's only this big, how do you do that? So I want to go look at that in a second. What was the motion to ensure transparency with the alternate juror and affidavit of counsel support? I believe that was they wanted to see the numbers pulled and look at every single one to make sure it was done appropriately. And Canoni's like, nope. So many people state guilty. Please explain why no one saw him with just enough snow to track a cat. I've asked, but no responses yet make sense. Everybody sees it a little different. Wishing he would have driven home more. This is a Boston police officer. What's with the shoddy investigation? This is a Boston police officer. Integrity? In life, we're always learning or we become stagnant. 100% agree with that. What is the biggest thing you've learned from AJ and might find yourself implementing? Incredibly charismatic, professional, experienced lawyer. And I feel like his demeanor was very different this trial than trial number 1. I feel like his theory and theme was very different. So don't be afraid to change. Don't be afraid to grow, change the way you look at something, change the way you attack something, different per trial, different per witness, potentially. Because I think he was very confident in the whole conspiracy proving it cover up, and he completely went into reasonable doubt instead. They still sprinkled that on to prove the reasonable doubt, kind of like the morphing of third-party culprit with Bowden. That's what I learned from him. Don't be married to your first thought. Be willing to adapt.
The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested.
I mean, that was mind-boggling to me. Multiple times, it was very clear what they were arguing, and then they'd be like, we're not saying that. We're not saying he was hit 24 miles an hour. We're not saying he was hit right here. We know what the impact is. We're not saying that's what Welcher's test said. It's like, then what are you saying? We should know your theory at this point. By the way, when Jackson said presumption of innocence, like it ticked a little with me because I'm like, she's not presumed innocent anymore. The Commonwealth could have proved her guilty beyond a reasonable doubt at this point. The jury has the evidence. She was presumed innocent before any evidence is presented. Just something that popped into my head.
That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might.
We knew this was coming too. We knew this was coming.
Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it.
I mean, this is bad. Once again, this is a point that if this is all you had, how the comments from the prosecutor and their team, how disingenuous they were, how potentially misleading they were. It's not just this, right? We know where he's going. We're almost done, by the way. For those of you that think this is almost too long, I don't think we've quite hit 2 hours on a video yet. We might get close. I think we'll be done just before 2 hours, but we'll be done soon.
And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false.
Now, he's hammering him. He's going in. He's eviscerating him. But it would have been so much better to say, you notice how the judge instructed you that Hank Brennan falsely insinuated something as a prosecutor? Even the judge told you that. That would have been so much stronger. Maybe not so much stronger, but even stronger. But Jackson was not going to let that go lightly. He handled it perfectly. It sounds a lot like the instruction I would have loved for the judge to have given and the instruction I would have asked for and been told no.
The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time.
Remember how Hank Brennan pointed at Karen Reed? He's like, you want to know who the bad guys are? 3 of them sitting right there did nothing about this.
It had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that
the fraud that was attempted on you. He accused them, the Commonwealth witnesses, of admitting perjury, and now the prosecutor attempted fraud.
That's dangerous. That's more than negligence.
He's talking about the prosecutors. It's more than negligence. It's dangerous. And he said something about like our community at some point. That would have been objected to. By the way, I think, I could be wrong. Was there 0 objections from both closing arguments? Usually good lawyers don't object to each other, I will just say. Unless it's something egregious.
That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with.
He's baiting him. I dare you to explain yourself. I dare you.
It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it.
Demand it.
Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was.
When he just said that, I thought, they know. Because it's not good when you do stuff like that and you give a defense lawyer that type of fodder to hammer with.
They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and We've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards,
When somebody was talking about that microdots posted, I guess, this demonstrative aid.
realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding,
By the way, this is very common to do, where you either put a bunch of marbles in a bucket and it's a weight, or a bunch of note cards, or a bunch of pieces of paper, or the top 10. I couldn't do top 10. There's 50 reasonable doubts in this case. Very common theme for defense lawyers.
mentally, even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Read. The truth is, Karen Read is not guilty. Not because of technicality.
All right, we are coming down to the last like 3 or 4 minutes of his closing. So this is where he's bringing it home. This is where he's bringing it home.
Read. The truth is, Karen Read is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And
that's what I wanted to see. That, and I get it. Possibilities are not good enough for the Commonwealth, but they didn't even show it was possible. When the defense is saying it's impossible, they showed it was possible that it lined up with the height. That's fine. I get that you're saying we don't know exactly, but give me a demonstration where the arm doesn't break and the taillight does, all the way down to the diffuser. That's how you eliminate reasonable doubt. That's what Welcher, the judge, was giving him time to do, and he could have done on rebuttal.
The reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Read because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth.
I loved that. They failed, they failed, they failed, they failed.
And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly,
don't let them get away with this failure. Grassfolk, my first super chat countering demonetization text. Please discuss if an impact is needed regarding Hank's fast reverse proposition, perhaps with Papa Tragos. Dismiss everything due to poor investigation instructions. Honestly, the Commonwealth does not get that benefit. They don't get the benefit of some people were over here. You guys discuss how you think a collision, or you guys discuss how John O'Keefe passed and why it was Karen Read's fault. Whichever one you figure out is fine with you. They need to prove it to you. They need to prove it to you.
do not let Michael Proctor get away with it.
Here we go.
And make no mistake.
This is where he does a vote for Michael Proctor is a vote for the Commonwealth, which I have been screaming that. That's what you got to do. Make them know. Whose team do you want to be on? Dr. Russell, Dr. La Posada, Wolf, and Rentschler? Or you want to be with Proctor and Yuri Buchanan and Dever? Who do you want to be with?
Get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty. Thank you.
What a great feeling to sit down from that too, right? Have you ever had a prosecution close in a case like this where medicals were not brought up? Yes. I have had them see prosecutors completely ignore certain defenses when they think they're totally irrelevant and just not going to win the day. Like I've absolutely seen that. I've absolutely seen that. I don't know how it's going to work here. Did you know that Bev was supposed to rotate to civil court, chose not to because she wanted to stay on this case? I heard something like that. Why was he face down after getting his occiput cracked? I think you're referring to somebody said they flipped him over. That just wasn't fleshed out enough for me to have a comment on. I'm so strongly on the D side at this point that I am fully part of the choir he's preaching to. Do you think AJ's closing is as powerful as someone who's still unconvinced? Here's what I'll say. There are jurors that might be in each choir. To convince them, sometimes the lawyers can, sometimes they can't. But what he's doing is he's arming the jurors that are with him and his choir to go back there and fight. My buddy who I went to law school with just texted me and said, man, you're doing such a great job of breaking down this criminal case as just a civil lawyer. That's funny. Thank you for that, Chris. Is this one of the best closings you've ever seen? Yes. This is up there for sure. Christy, Peter, have you heard what happened right before the jury instructions, after the sidebar, after lunch, when the judge was asked if she was okay? Anyone know? I have no idea. The chat might know, but I have no idea. It has been a pleasure viewing your coverage of this case. Huge fan here. What case are you covering next? We've got Adelson and Koberger coming up in August. I don't know if I'll need a break or not, right? This has been a lot. It's been crazy. Definitely the last Saturday stream tomorrow for a while. But make sure you guys all subscribe. There's like a third of people that watch all these videos and don't subscribe. If you're on Twitter watching, come subscribe on YouTube as well. And make sure you guys hit the like button wherever you're watching. Peter, did you hear they had a screen up the whole time labeled reasonable doubt, adding points to it? Yeah, I think that can be very, very impactful. LK, did Hank Brennan or his team actually say there were no x-rays? What question did he ask about x-rays? Did he really have them for 3 years? I can't remember now if Jackson asked or if Brennan asked, but Welcher was like, there's no x-rays, so we can't prove there was no fractures. Very clear that everybody let Welcher sit with that. Now, is it because they didn't know, or is it strategic? I don't know. But it definitely came out with Welcher. Why do I find Brennan sleazy but not Brian Steele? Everybody's got different vibes with lawyers, right? Everybody's got different vibes. LMJA, thank you for this super sticker. This is what we're going to ride out with. We're just under 2 hours. I appreciate you guys. Judy, thanks for gifting 5 Lawyer You Know memberships. Until next time, I don't know what John just texted me. Hopefully it's not important. All right, whatever. All right, that's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.